In the Karen Read case, Judge Cannone tells Read and her defense, no expenses for your expert who flew all the way from Phoenix, Arizona to go to the Canton Police Department. But that doesn't really answer all the questions about the mystery video.
Is it really fair for Karen Read's experts' expenses to not be paid? I'm Lainey Law.
And I'm attorney Andrew Myers.
And Andrew, is this something normal that it would be turned down so quickly? Is this a situation that is this something that's typically denied in court?
Well, I think, as you know, there's nothing normal about this case. I mean, Karen Read has been receiving dribs and drabs of this video, the inverted video of the Lexus in the Canton Police Department Sally Port. It was shown backwards. And so now her attorneys are saying, wait a minute, we've received stuff in dribs and drabs, and we're going to tell you in a minute some mystery stuff that's kind of brand new that's come out in these hearings on this issue. I think it was a little bit unusual that a hearing had been held on the motion to pay her expert for coming all the way from Phoenix, Arizona, and going to Canton Police Department and not finding not only the video, but the logs, which you know more about than me. Same day in a snowstorm, Judge Cannone denied the motion. So the funny thing was, to me, was a lengthy, not as lengthy, of course, as some previous issues. In a lengthy hearing, the attorneys went back and forth, and Mr. Brennan was kind of saying that he's the good guy in all of this, and the judge bought it, as we're going to get into. But going all the way back to the beginning, defense attorney Alan Jackson had explained in court that the video of Karen Read's Lexus at the Canton Police Department was produced to her defense only in pieces. And there's even a new video, never before seen, just recently unveiled, of the Lexus actually backing into the police department in Canton. And we've never even seen that.
Why were we getting videos from January 29th, 2022, 2.5 years later? And why were some of those videos altered or manipulated and not in their proper format? We still don't have answers to those questions.
And that's the issue right there, that, the video that was shown to the jury, first of all, it was never produced before the trial. That's a huge problem right there. That's a huge problem right there. But it was also backwards, which shows that it was manipulated. It was edited. Use whatever words you want. That it was not the original video.
I just want to verify for myself and our viewers who might not be as familiar, but if you're not producing the evidence before court, that's 4 out of 5 times the case is going to get dismissed, right? If you're not producing everything?
There's a panoply of remedies that the court could have employed right then at that time, up to and including, dismissing the case, not letting them use that video, excoriating the fence in front of the jury. There is a whole panoply of things. But when we talked to Mark Betterow about this, he said if this had happened in New York where he practices, yes, the case would have been dismissed. But it went on.
And literally, while we're asking that question and while we're pondering that question, a couple of days ago, we're getting yet more videos, scraps, piecemeal. We got another Sally Port video just a few days ago, this one showing the Lexus backing into the Sally Port from some exterior camera. And that also is exculpatory evidence. Mr. Brennan writes in his opposition that the idea that the defense has been misled or was misled in its efforts to try to go secure that DVR footage is a distortion of the facts with, quote, no legal merit. Really? A distortion of the facts with no legal merit? Where's all this footage coming from, if not the DVR? It's the only place it was held. It's the only place it was captured. So of course we were misled.
So I don't know if you caught that, but there's a whole new video that had not been disclosed before the trial, and it was only just recently disclosed in dribs and drabs and little snips and snails and puppy dogs' tails. there's video from the external camera at the Canton Police Department showing the Lexus backing in. Now that would be a blockbuster, because what does the taillight look like when it's backing
Well,
in?
and also what he was saying is like they got the video from the DVR or whatever it is, that they were supposed to be able to go and find the original information. So he has a great point. Where are these coming from?
Exactly. So Special Prosecutor Hank Brennan tried to portray himself as the good guy. He was trying to be the nice guy, cooperating fully, letting that Karen Read expert go to the Canton Police Department. But in explaining his follow-up, Brennan revealed a previously unknown backup mystery video.
They came out on their own volition. I extended the courtesy as much as I could, made no promises. I was clear, I was very uncertain about what would be on there since I never looked at it. After I learned there was no information on the NVR, I took the initiative and went to the police department. I viewed the police department, the cameras, I spoke to personnel, and I spoke to the retired individual who then was responsible for providing video upon request. And when I spoke to him, he told me in conversation that he would routinely store a copy on a file he noted as a detective file or on his hard drive. That was news to me. I thought that was helpful, so I notified the defense about my conversation. I was not trying to lure them back to Canton or have them spend money. I was trying to, as I always do, be as transparent as I could and as helpful as I could. Now, what I simply should have done and could have done is I could have gone to that detective file and downloaded the video and given a copy to the defense. That's my obligation, no more. But I didn't. I extended the courtesy that if they wanted to come and look at that file before we opened it, so it could be beyond reproach, they were invited to do that.
Mr. Brennan's demeanor, to me, always seems to be that he's doing everybody a favor. He's doing the whole world a favor in, oh, well, so we didn't disclose this stuff before. You know, I could have downloaded this crazy detective file, but I didn't. You know, you have to make an extra step. I mean, he's kind of, I hate to use the word, he's trying to stick it to him, but at the same time, trying to portray himself as I'm being the nice guy.
Well, and that's how it comes off as him trying to like take the blame off of himself, in the sense where he's just like, oh, well, you know, I wasn't sending them to Canton. I could have sent the video to them, but I wanted to give them the opportunity. They did not get that opportunity. Is the way that I feel about this situation.
Well, if you think that's bad, Mr. Brennan also tried to turn it around on the defense team for Karen Read, that they waited so long to think about even send it. It's all their fault. First of all, it's their fault for coming in the first place, but secondarily, it's all their fault for waiting all this time to send their expert to the Canton Police Department.
But he admitted that he didn't do it. He should have also just have sent it. Like, he admitted that he didn't do it. Like, send it to them and also just be like, and you can go check it on yourself too. But then also allow them to go check on it.
And the other breaking news in my mind is that this retired detective downloaded it all. He downloaded it all into this secret detective file and didn't tell anybody. So, I mean, first of all, it's a huge violation of Brady, to my mind, and a huge violation of discovery, where we are all told under the rules of procedure, give the other side everything. Give the other side everything that you have. But in a criminal case, if you do not give them exculpatory information, you are required to do so under the Constitution of the United States. That, my friends, is a Brady violation. So I just thought it was crazy that this detective saved a full copy. And I'm thinking to myself, why would he do that? Why would he do that? Does he just not trust the prosecutors? Does he not trust the other people within the Canton Police Department that maybe this is a regular thing? Maybe they take their videos and cut them up or destroy them or turn them backwards or edit them. So this detective says to himself, I don't trust these other guys I work with, so I better save this stuff. And then when it became a big issue, even though he's retired, you know, you'd have to be living under a rock to not understand that this is a major issue and a major case that I think, you know, 99.9% of the people that live in Massachusetts and in 50 countries, we're going to get to that in a minute, know about. I just think it's nuts.
Yeah, I mean, ultimately, I think what he was doing to an extent was proper. And I think that's a good point that you bring up, that he had the foresight to be doing that for some issues of this. I think if you have security footage, I mean, I think in most scenarios, it should be preserved for a certain amount of time, whether that be 5 years. So the situation is sketchy.
It's very sketchy. So Brennan tried to say, well, first of all, they should have known better, that it wasn't there. But second of all, why'd they wait so long to, even send their guy to the police department?
The defense waited almost 3 years. The defense was very clear about my uncertainty would be on that tape. And now they stand before the court and they try to parlay this into some type of injustice for their cause. The case they cite, Commonwealth v. Frith, the district court was overruled in assessing costs because there was no egregious violation. This is not a Brady case. This is not a setup.
Oh, and by the way, the case that Mr. Brennan is talking about there was a district court case that the defense did not cite, but actually the Massachusetts Appellate Court had cited in their case, in which they were saying, yes, there should be sanctions up to and including assigning costs to the party that's violated the rules. And so it was the appellate court that made the point. So the defense, the district court case was irrelevant. And Jackson pushed back, saying that, come on now, this is a video. This is one video. We only got it in dribs and drabs and pieces of it, pieces and bits. One of the quotes was bites and bits. Never, and the inverted video of the Lexus was never produced to them until mid-trial. And he argued very strongly that, my friends, is in fact a Brady violation.
It is a Brady case. There's no question that the data on those videos are Brady. They're exculpatory. That's where we start. So Mr. Brennan can say all day long, that's not a Brady case, don't worry about it, let's just sweep this under the carpet like we've done everything else. There's nothing to see here. That's not true. It's a Brady case because the information that we have now received from that DVR, that NVR system, is exculpatory to Ms. Reed. That's why I cited
Brian Higgins part?
That's why I cited the Brian Higgins part. Correct. And I suspect there's a lot more on there as well. The inverted video part is also Brady, which we got in the middle of trial.
So what he's talking about there, we mentioned it in our previous episode when we went over the actual motion that the defense had brought, was Brian Higgins. I mean, there was a video that never came out before the last trial, or even during the trial, or even until very recently, until Mr. Brennan entered the case. And again, he's being the nice guy and he's being cooperative. So he disclosed more bits and drabs of this video, one of which was a video of Brian Higgins at 1:35 a.m., January 29th, 2022. Remember, that is the night that Karen Read dropped off John O'Keefe at the home, Fairview Avenue. But this shows that Brian Higgins at 1:35 a.m. on January 29th was standing in the parking lot of the Canton Police Department talking on his cell phone. During the trial, he never admitted making a phone call that night. And in fact, he testified that he never made phone calls that night. So that was a key piece of evidence in that trial. And it wasn't even disclosed until Mr. Brennan came into the case and said, okay, let's give him everything. We've given him everything, but let's give him everything again. And it just shows again that the actual entire original digital video is somewhere apart from the detective file. It's somewhere, and it's been put in the editing bin.
Well, and, ultimately, it's kind of annoying now because he said, like, oh, he never made the call. He wasn't on the phone with anybody. But now we have this that proves that he was on the phone with someone. Oh, well, he was drunk. Well, he didn't remember. Like, I feel like it's just going to get swept under the rug. So even though it is something that strongly goes against, like, what he had previously said, it's just like, it doesn't even matter how many moments we have like this. It just seems like we're just sweeping everything under the rug.
So... you really have to wonder, you really have to wonder, why is the Commonwealth not providing this full video? I think our viewers know. Our viewers know. There's exculpatory stuff in there. There's stuff like the bombshell about Brian Higgins being outside talking on his phone. That was a different video, different camera, different angle, granted. But think about this. Why is the Commonwealth not revealing all of the video, and why do they fight so hard? On the one hand saying, we gave him everything, and on the other hand, just only giving it in dribs and drabs. I mean, we do these episodes and we have a master file with everything in it, but sometimes I put my coffee down too loud, and we can edit that out. We can edit in some of the graphics, we can do, but if push came to shove, we have an original somewhere, and
very easily accessible.
Yeah, it's easily accessible. It's easily accessible unless you erase it. Unless you erase it, which after we're done editing it and dropping it, at some point I clean out my laptop and my removable drive or remote drive, because if you put too much stuff on there and you don't need it, but it exists, it's there, and they've just really fought. And Jackson also emphasized that no one on the prosecution side ever fessed up to manipulating the inverted video and showing it to the jury. No one ever fessed up to that.
When there is a discovery violation, when there is a Brady violation, and there is no question that that's what's before this court, blatant discovery and Brady violations. The Commonwealth doesn't, the court may remember, by the way, on the witness stand when these videos were coming in piecemeal, especially the inverted video, 2 or 3 witnesses all went like this. I wasn't the one totally. I wasn't the one that downloaded it. I wasn't the one that downloaded. I don't know where it came from. It just ended up on my desk on a flash drive. I don't know where it came from. Everybody was pointing fingers at everybody else. Nobody could establish a single chain of custody for those videos, and we still don't have it. So, Chief Rafferty's statement. Yeah, come on out. No hesitation whatsoever. They can come look at it. I suspect it's because she knew it wasn't there. This was we were led in a circular runaround.
You know what I was thinking of when he was saying that they were all pointing the finger at each other? I was thinking about that classic. It's a little statuesque with 3 monkeys. See no evil, hear no evil, speak no evil. That's what it reminds me of. And it's just not funny. If you're Karen Read or one of her attorneys, it's not funny because, it's obvious that they were given the runaround here.
It's like the meme format of Spider-Man pointing at the other Spider-Man trying to figure out who did it. But I think something that he pointed out that was really important that attorney Mark Betterow mentioned when he was on our podcast is the chain of custody, having a very clear chain of custody of where the file came from. That should be something that is very clear and easy to prove. Where did this random USB that's just on my desk come from? Who put it there? Why don't you know? Who uploaded it? What day was it uploaded? Is there not a system in place where we're just, if you're putting evidence in, shouldn't it just be uploaded and then you can see the user that did it? It's crazy.
Yeah, so now if I'm the attorney in this case and it had just been revealed that there's this detective's file where he downloaded everything, I'm immediately filing a discovery request for that. I mean, yes, I know it's late. Discovery motions are disfavored this close to trial, but that's important. There's very good cause to file another discovery motion. So I'm filing immediately a discovery request that I want that, and I'm doing it. I'm not doing it on the telephone. I'm putting it in writing, and I'm filing it immediately right now today, because in Massachusetts, as most places anyhow, we file everything electronically, and we have to serve the other party. But I mean, Mr. Brennan's right there. Everybody who practices law on this case has his contact information. So I'm filing a discovery motion. I want to see it. So something that was, and you asked me this before. Yeah, it's pretty unusual in a case like this, in a matter like this, for the judge to issue a written ruling same day. There's a couple of things they can do. They can rule from the bench. They can say motion allowed, motion denied. Or they can take it under advisement, and she took it under advisement. But we were in the middle of a snowstorm when this hearing was going on. One of our usual New England snowstorms. We all, bear it. It's no big deal. But same day, she issued a written ruling. So let's take a look at that.
So during that day of the snowstorm, while everybody was shuffling, she was out denying stuff.
She shoveled something. Here's the motion. Here's the order. This is the decision and order on defendant's motion to recover expert-related expenses from the Commonwealth. After hearing, the one we just took a look at, after hearing and review of the pleadings, the court credits the affidavit of Special Prosecutor Hank Brennan, paragraph 6. Attorney Jackson expressed concern that the materials may no longer exist on the NVR given the time that had passed since the event. I agreed with him and told him that I had no knowledge whether the materials still existed or were overwritten given the passage of time. In light of the averment of ADA Brennan and in light of Attorney Jackson's acknowledgement during the hearing that he and ADA Brennan discussed his concerns regarding the likelihood of the video still existing, the motion to recover costs is denied. Further, although Attorney Jackson argued for sanctions for an alleged violation of Mass Rule of Criminal Procedure 14, there's nothing in the written pleading raising this argument, and the issue is therefore not currently before the court. Defendant's motion to recover expert-related expenses is hereby denied. And the problem I really had with that is that tells part of the story. It cherry picks one paragraph from Mr. Brennan's pleadings, and it doesn't really address the real central issue behind the whole thing. And I feel that Mr. Brennan wasn't being totally, he says that he was trying to cooperate and let him come. And, if a phone call was made that we want to come out there, shouldn't Mr. Brennan at that time have said, geez, I have it. It's in a file. It's in my desk drawer, or it's in Mr. Lally's desk drawer. Shouldn't he have said, instead of coming all the way down to the Canton Police Department, make that your first stop and then come out to my office and we'll find that for you. Because the purpose behind the whole thing was to get the original video. So if he was really being the nice guy and the cooperative guy, shouldn't he have looked to the goal and not just the immediate, we're going to send the expert to Canton?
Yeah.
It doesn't.
Definitely. And I don't know. I'm not in this type of legal proceeding situation, but I feel like a lot of the time, instead of just letting someone go get something themselves, I'll just send it to them, or even just trying to be as cooperative as possible. I don't know. I don't think it takes that much.
I just I shook my head when I read that the ruling was made so quickly. I wonder if it was get out the dun dun dun. I wonder if it was written before the hearing.
Dun dun dun.
So I don't know. The only other thing I have to say before we conclude is that in the last week, we've had 2 new countries just in the last day. Nicaragua has sent comments to us. This is the list of countries that have sent commenters to our comment section. And those are really the ones we know about. I mean, sometimes people don't even bother to comment. Sometimes people just watch. Maybe they'll watch half of it, move on. Maybe they'll watch it and they have no comment. But there are now 47 countries from which we have received comments in our comments section. And those are the new ones, Philippines and Nicaragua. So thank you. Welcome. Lo siento, no hablo español.
Soon enough, we're going to have more countries than states. It's crazy.
Yeah, we're going for that 50. Should we stop counting when we get to 50?
Oh, I don't know. I think it's kind of nice. I mean, what do you guys think? I think, obviously we enjoy making these videos and we enjoy reading your comments, but this kind of just puts the whole thing into scope as to how global the situation is.
Yeah, because, there are a lot of cases going on right now. There are many, many, many cases going on right now. But this one and the other one we follow, the Koberger, Idaho 4 case, are being followed internationally. I don't know if some of the other ones like Suitcase Sarah Boone or some of the others, I don't know if they draw that kind of international attention, but this one certainly has, and I think with good reason, because there are so many questions about what's going on in the case. I mean, from the very beginning to the questions about this video that we're talking about today. It just really doesn't make sense. And it would seem to me that at some point, someone somewhere should sit everybody down in a mediation, in an arbitration, in a discovery mediation, or in the judge's chambers. Sometimes when there are issues, a judge will have the parties go into their office. It's called the chambers. And the judge, there's no cameras, there's no press, there's nobody, and there's not even a stenographer. It's quiet. And why wouldn't there be a chambers conversation? Listen, guys, there needs to be a full video. I want it tomorrow. Let's stop fooling around. Think about all the time and energy and expense. And the only other thing that happened during this particular hearing, well, a couple of things. She has recalculated the order for when things have to happen. She's going to give Alan Jackson until early. It was the 11th of February, which is coming up awful quickly.
Gosh.
She's going to give him until the 21st of February to file his motion to dismiss the case for extraordinary governmental abuse in this case. And then the hearing will come in the next month. But as we've said before, based on what's happened in this case, that's not going to be allowed. The motion to dismiss, it'll be grounds for appeal. It will be excellent grounds for appeal. If Ms. Reed, who we're looking at now, if she is found guilty, the motion to dismiss will sow the ground for appeal. And we hope she's not found guilty. But yeah, I said it. Our commenters are going to, you're biased. No, I'm really not biased. I'm really not biased. I'm trying to be as objective as I can. But just seeing what you see in this case, it makes no sense. It really makes no sense. So the motion to dismiss will verify the facts and cite the law so that the appeals court can do cleanup. And that's all that'll be. But also, even though the judge, Cannone, did file an amended scheduling order, she's holding fast to that April 1st trial date. So
I know.
Looks like there'll be an April 1st trial one way or the other. Why they're starting on an April 1st, I don't know.
Because it's a funny prank on Massachusetts to keep wasting their money like this.
Yeah, just the way that sounds. And then there was one other thing, and I can't remember what it was. There was one other. She is allowing the Commonwealth's motion for reciprocal discovery on the ARCA experts. Mr. Brennan, he's 0 for 2 on the experts. There was a motion to exclude the expert, Dr. Marie Russell. That took 2 days. That failed. Then there was the motion to determine whether or not Richard Green should be allowed to testify. Judge Cannone stopped that. She says, I've heard enough. I've heard enough. We're not going to have an additional voir dire on her. So Richard Green will be allowed to testify. She said that is a matter of opinion or a difference of opinion. It's battling experts. That's for the jury. That's what we've been saying all along anyhow. So now Mr. Brennan is going after a third expert, the ARCA experts, the ones that said there was no contact between the car and Mr. O'Keefe, and Mr. O'Keefe was not hit by a car. Remember those ones? Mm-hmm. So now he's going after those. He's 0 for 2. We'll see what happens with that. But the judge allowed his motion for reciprocal discovery. He wants more materials out of those experts. And so he's on a tight leash, though, with the trial being scheduled on the 1st and the judge holding fast to that date. I don't see how there could be a hearing on that. And I can't see that there would ever be another 2-day hearing like the one on Dr. Russell. That was crazy. That was, if I've ever seen a waste of judicial resources in my 35 years of practicing law, That's it.
Yeah.
Anyhow.
It just comes off bad. It just comes off as if he doesn't have a case, so he gets rid of like all the experts that they have that were already allowed, that were already permitted, and seem to be totally fine the first round. If that's your biggest fight for this prosecution right now, then do you really have ground to stand on? I don't know.
So I guess my closing thought is, Karen Read is preparing for another trial. The trial will very likely, unless there's a bombshell, will happen on April 1st. I know there's other people out there saying, oh, no, these Brady violation things will push the schedule back. No, this judge is specially assigned, which means in Massachusetts, she's the judge. Sometimes we have cases where you never know who the judge is going to be. You file the case and you get an initial hearing with one judge, then you get a discovery hearing with another judge, then you get the pretrial with a different judge. No. Judge Cannone has been specially assigned to this case, and that means that she will be the judge. And she said all along, we're doing it on April 1st. And I've got to think, if I were a judge and this was in my lap, I've got to think that she's thinking, I want to get rid of this. This is a hot potato. It can't be comfortable. I've said it before. We invite your comments. Please comment, but we don't like name calling. No matter how you feel, don't call anyone a name. Tell us why you feel that way. Tell us why you feel that this judge was right or wrong. Tell us why you think the prosecutor was right or wrong. But where I was going with that comment was, this can't be any fun. No matter how you feel about the judge, this can't be any fun for her. Mm-hmm. It's her job. She's specially appointed. She took a lot of grief the first time around in the trial. It's going to be another lengthy trial. It was 2.5 months. It would have been shorter if they'd held 5-day trials. 5-day-a-week trials. So if I were her, I would also want to get it off my desk ASAP and just, make evidentiary rulings as clean as possible. Tell the parties, we're starting in the first. I want your witness list. I want to know, do you have witnesses lined up in case you go through the first day's witnesses right away? And so that's my final thought is that, oh my gosh, I hope the second trial goes a little bit more cleanly than the first. What are your closing thoughts?
No, my closing thoughts is that this just sucks. I hope that whoever's watching this right now, if you're American, can just empathize and relate to this, how cruddy this situation is. Sitting here in court, needing to defend yourself from police officers who you've seen their text messages were just bad-mouthing you when they're supposed to be the ones trying to get to the bottom of this case. It just doesn't really feel like things are working out for the common person in this situation. And it just, there's a reason that people all around the world are watching this case. And if you are watching our videos, hi, thank you. Leave a comment down below and tell us what other cases you're watching along with this one, because I'm assuming that if you're watching the Karen Read case, this can't be the only thing that you're watching in America court media. So let us know. The situation is coming off as it just looks very messy. And I understand that everybody's just trying to do their jobs, and that when you're in court, it's his job to try to do the best that he can. And it's his job to try to knock down the expert witnesses. But it doesn't really seem like they're trying to get to justice in this scenario.
I thought it was funny when I asked you for your closing thoughts. You said this sucks, because the reason I say that is because after the hearing, which occurred during a snowstorm, one of the TV stations caught up with attorney Alan Jackson walking out in his heavy car. He's from Los Angeles. He isn't like this. And so they came up and asked him a question, and it was on the Boston TV station in the evening. And they asked him a question about the hearing. And that's what he says. This sucks. No, he said, can I say that on TV?
Can you say suck on TV? Because that would have sucked. Oh, watch out.
And apparently you can, because they did let him say it on TV. Whether YouTube lets us get away with it or not, I don't know. Thank you very much for watching, and remember to be kind to everyone.
Whether you are in the grocery store, the gas station, or anywhere else, Please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.